Thanks for having me, and thanks for coming out on a lovely rainy Houston day. So happy to be here. There is a little handout. I think I have enough.
Here's a benchmark.
And a benchmark. So if anybody comes in, we can share that. So introduction to estate planning. I am an estate planning attorney. A little bit more about me. Who am I? Thuy Tran. So unless you know another Thuy, there is no way you would know how to pronounce my name. I always use it phonetically. Sounds like Tweety Bird. That's probably the easiest way to connect how to pronounce my name. First and foremost, I am a mom. That's the title I'm most proud of. This is my family. This is actually Yosemite last year. I have a husband that we have been married. We just celebrated our 24th anniversary. He has put up with me for 24 years. We're still going, so that's good for him. We have 2 children. My oldest is Austin. He just graduated from college. And our family's ongoing joke is he is off the payroll. So youngest is Autumn. She just finished her 2nd year at A&M. Another joke in our family, so my husband and I are both Longhorns. We are such Longhorns, we named our son Austin, and neither of our children went to UT. So we like to joke that we failed in parenting in that regard. I went to UT. I have a Bachelor of Science in Applied Learning and Development. What is that? I thought when I started out that I actually was going to be a teacher forever. I taught elementary education. I am still, ironically, licensed to teach up to 8th grade here in Texas. You could not pay me enough to go back in the classroom, unfortunately, given the climate. However, once a teacher, always a teacher. So what does that mean? How I practice law, that teaching and wanting to educate is very important to me as an attorney. So what that means is for all of my clients, I want them to truly understand what they're signing and not just because he's putting it in front of you and saying, hey, this is really important. I got my law degree from the University of Houston here, great program. A little fun fact about me, I love food. Whether it's eating it, cooking it, watching videos online and trying to experiment. I love food. Here is a selection of, for anybody who is adventurous, Vietnamese food. And I think most people are familiar, if you've had Vietnamese cuisine before, with pho, which is the bottom right-hand corner. That's a Vietnamese noodle soup, delicious. It's kind of like our chicken noodle soup. But that is not the only Vietnamese dish that you should try when you're feeling adventurous. Those other dishes right there are some of our top favorite dishes. I have cooked some with success and some not so much, but that's me. Okay, so here I always like to start out with a comic strip, estate planning. What is estate planning? Well, I'll let you give you a second to read this. What does that mean? Can we do this? Can we just put Post-it notes on things that we want to leave? Answer, no. That's definitely not how it is. Please don't do this. We have seen it done and it doesn't work like that. What is an estate? So let's start out with that. What is an estate? Real simply, everything of value that you own. That is your estate. That includes money, which is cash. Nowadays, crypto is also included. All your bank accounts, investments, retirement. Includes your home, real estate interests, land, business interests, so home. I always call these the Oreo cows. I'm not quite sure what they're called, but every time I see them, I get giddy because they look like an Oreo. But you guys may have clients who have land, whether it's ag land or income producing land. That is also part of their estate. Personal property, pets, collections, book collections. I have clients who have baseball card collections. People like to collect stuff. Jewelry, your pets. Interestingly enough, under the law, even though your pets are living beings, they actually are considered, for estate planning purposes, property, even though they are living. So we have families who, clients whose pets are like their family members. So that's also included in what we consider their estate and what kind of planning may make sense for them. Life insurance is the last one on this list of generally what can be considered your estate. Okay, so it's everything of some kind of value. What is an estate plan? And here's another picture of my family. Why? Because for me, every estate plan, the purpose and the most important thing is taking care of our loved ones if we're not here. Because in this world, everybody in this room will die. So when we leave, what is the legacy we want to leave our children or our loved ones? That's the purpose of estate plan. To me, estate planning, the way I explain it is it's twofold. We are addressing two potential situations. What are the two scenarios? Number one, incapacity planning. Okay? So in the handout in front of you, I have two sections of documents that are related to an estate plan. What are incapacity planning documents? The example I give is that you go out and you get hit by a metro bus. Good news is you survived the bus crash. Bad news is you're in a coma, meaning when you're in that coma, you can't do things for yourself, right? So we need to put decision makers, people in place to take care of yourself or you during the time that you're incapacitated. That's what incapacity addresses. First on that list is medical power of attorney. What is your medical power of attorney? Medical power of attorney is who you want to name to work with the doctors, hospital, the best course of treatment for you. Okay, so when it comes to your medical decision maker, this is what I recommend to my clients of what you keep in mind, what you think about. First and foremost, this person that you name needs to be strong enough to adhere to your wishes. What do I mean by that? Let's say the bus crash was really bad. And unfortunately, the only thing keeping you alive is life support. So this is the worst case scenario, if you can imagine. Terminal condition, irreversible condition, persistent vegetative stage, and the only thing keeping you alive is because you are hooked to these machines, but that is not how you want to live. Whoever you've named in your medical power of attorney as your decision maker should be strong enough to make that difficult decision to remove you from life support and not feel like they killed you. Here's my personal example. My mom would never be able to do that. She would, even knowing that's not how I would want to live, would always hold out hope. And because I know that about my mom, I'm not going to even put her in that position. So behind my husband, I've had a conversation with my sister. I'm going to hope she's a little bit heartbroken first. But I do have the confidence that because we've talked about it, she's strong enough to make that difficult decision for me. Okay? So when it comes to your healthcare, medical decision maker, that is what I want you to consider when you're naming these people in that role. Okay? The next document under this list for incapacity planning is HIPAA authorization. What is HIPAA? HIPAA is a federal privacy statute that says only authorized individuals have access to your private health information. So if you've been to the doctor lately, you've signed off on a notice of your federal rights under HIPAA. Why is it such a big deal, or why do you see this in every hospital and doctor's office? Because any doctor or hospital or healthcare provider that has found to have violated HIPAA by giving your private healthcare information to unauthorized individuals, they can be fined tens of thousands of dollars because it's per occurrence. So that's why hospitals are very scared of HIPAA. HIPAA authorization is a separate standalone document that I have my clients sign that says, look, the people I've named in my medical power of attorney should also have access to my medical records. records. Well, if you think about it, the role you're asking them to serve in is they're going to be making your medical decisions for you when you can't. So it makes sense for you to give them access to your medical records so they can make an informed decision. So for instance, my sister and I, back to my example, my sister and I are very close. But she doesn't know every blood test I've ever had, every procedure I've ever had. So giving her access to my medical records during the time that she's serving makes sense, so she can make an informed decision about what should happen with my health care if, God forbid, something should happen to me and I'm not able to, and then my husband is not able to do that for me. Advanced Healthcare Directive is the third healthcare related document for incapacity. What is that? It drives me crazy because it's referred to as multiple things. Sometimes it's called a living will, sometimes it's called a directive to decisions. All of that is the same document. This is where you can decide and you can tell your loved ones, if I am ever diagnosed with a terminal irreversible condition and death is imminent, meaning regardless of what happens, I'm going to die, but I do not want to live in this way. This is where you can tell your loved ones. It's a document you can sign. This one is optional for my clients. To me, the most important thing is if it's important to you. And so that's what I will ask my clients. Is this important to you? If you feel strongly about this, let's put it into writing. It's not automatic, meaning if this is in your health file and a doctor comes across this and says, look, we're going to stop everything, we're just going to go unplug you, it doesn't happen that way. From a liability standpoint, from the hospital, no hospital ever wants to be accused of removing life support before everything has been exhausted to keep that person alive. But to me, the biggest advantage of having this advanced healthcare directive in place is for your loved ones. If you've not had that conversation with them, it is basically telling them it's okay. If I could tell you what I want, this is what I want done. So to me, that's the biggest important reason why to have that document in place if you have that strong opinion. Okay. So those are the three healthcare related documents for every estate plan that we do, that we have all of our clients consider. The next one is agent for disposition of remains. So what is that? So for some clients, that's important, that they want to have somebody specifically named in charge to handle their remains. Where we see that is people who have very strong religious beliefs, maybe, and how they would like their body handled after they're gone. By and large, though, the majority of the public doesn't need to execute an agent for disposition of remains, but is there and available if you have strong opinions about that. Okay? So those are the healthcare documents. I'm going to pause here. Does anybody have any questions?
You can change these at any time, right?
Correct. So long as you have capacity, that's the big one. As long as you have capacity, you should change and adjust your document. So what I tell clients is, please check in with me every 3 to 5 years. That's usually the typical window that I have clients check in, especially nowadays. We have Zoom. We hop on a Zoom call. We kind of go through things. One of the things that we talk about are your decision makers. Does it still make sense, this hierarchy of people that you've named? Probably the most common reason why we may change decision makers is people get sick. But yes, just like your life probably looks very different from 5 years ago, so should your estate plan evolve over time, because in 5 years your life is going to look different. The next incapacity planning document I always have my clients put into place is a durable power of attorney. It's also known as a financial power of attorney POA. What is that? That is, unlike your healthcare decision maker, this person is responsible for managing your money for you. Meaning during the time that you're incapacitated, they're paying your bills. They are managing your money. So what do I want you to keep in mind when you're thinking about who to name in this role? It's a little bit different. Financial power of attorney, to me, the first thing that I ask clients to be able to tell me is that they are completely trustworthy. That's the most important thing. Why? You are trusting them to take care of you financially. And then if you're gone and, for instance, you have children, you're trusting them to take care of your estate for the benefit of your children or your loved ones. Trustworthy is the biggest thing, meaning This doesn't have to be somebody with a CPA background. It doesn't have to be somebody who is, the strongest math person in the room. They need to be trustworthy, meaning they're not the person who is asking to borrow money from you. That's not the ideal person to serve in a financial role. They're not somebody who is coming to you with a get-rich-quick scheme, saying, hey, let's take all of our money, let's throw it into crypto or other things that are high risk. Because when they're serving in this role, it's a fiduciary role, they need to be conservative during the time that they're serving. Declaration of Guardian is the next document, and this actually applies at incapacity, but also only when your financial power of attorney doesn't cover everything. Sometimes there are instances where we need to seek a guardianship over an individual. There's actually two types of guardians. There's the guardian of the estate, and then there's the guardian of the person. What's the difference? Guardian of the estate is who is going to manage my money. Who do I trust? It's typically the same hierarchy of people that are named into financial power of attorney. Guardian of the person is a little bit different. That's who's going to take care of you day to day. So back to the example of you being hit by a bus and you're incapacitated. Good news is you're going to survive this bus crash, but maybe you have a long-term disability that will require guardianship over you to take care of you. Who's this guardian of the person? Who's going to take me to the doctor? Who's going to take me to my PT therapy appointments? That's the role of this person. That's your guardianship, personally. But for the majority of my clients who have minor children, the last document in this chart is the most important, and that's the Declaration of Guardian for minor children. What is that? Same thing. It's where you can decide, if you are no longer here, who you would prefer to have serve in the role of guardianship for your children. There's two types of guardians. There's guardian of the estate, who's going to manage my children's money. Well, realistically, our minor children don't have their own money. Their money is mom and dad's money. So it's the same hierarchy of people in your financial power of attorney. Guardian of the person is a little bit different. And by and large, this is the most challenging decision for my clients, for my parents. Why? This is the person who is going to be responsible for raising your children if you're not here. When parents think of who to name in this role, this is what I ask them to consider. Think about what your parenting objectives are for your children. And then also think about what your parenting style is. And then whoever you name in this role, should something happen to you, have this person, this parent, be very similar to parenting style and objectives that you have. What do I mean by that? If you are a type A tiger mom parent, meaning you're very disciplined, very regimented, please do not leave your children with somebody who, what I call more of a hippie, free will, do whatever you want kind of parent, because those two parenting styles are significantly different, and that will be that much more challenging for your children to adapt to those changes. So if you imagine, anytime we lose a parent, it is incredibly traumatic experience for our children. And so another point of these documents is to ease that transition from mom and dad being here to mom and dad no longer being here. And so if you put them and leave them with somebody who is completely different from how you parent or how you envision you want them parented, it is that much more challenging for your children to adjust. Okay. The other thing when it comes to guardianship, I have clients consider a divide and conquer kind of approach, meaning we have a different set of people that we want to name for financial, and we have a different set of people that we want to name for the guardian of the person. Why does that make sense for some families? It's a divide and conquer approach. And there's also, in that approach, because you have two different people serving these roles, and also inherent checks and balances system. Meaning, whoever's serving as the guardian of the estate for your children, before they're allowed to make a distribution of money to your guardian of the person, they're required to make sure that this money is actually going to what it's supposed to be going to, and that it is actually for the benefit of your children. Vice versa, the guardian of the person has the authority to double check the guardian of the estate's investments. Are we investing correctly? Are we trying to make this money last as long as possible? We're not taking everything and we're not throwing it in crypto, right? We are managing this to the best we can to make this last as long as possible. So for some families, that makes sense, that checks and balances system. For other families, they are comfortable with the same hierarchy of people. What I tell clients is this: you know your people better than I do. Just to keep in mind what the role is that you are giving them, what you're asking and trusting them to do. Guardian of the estate, manage my children's money for them. Guardian of the person, taking care of them day to day. Questions? Sure.
For that example specifically, I guess how much prep work goes into tying, I guess, the two together if you have one doing financial and one, doing like a two-person, I guess, guardianship? And then how specific, I guess, then would the estate plan need to be to address all the different, I guess, benchmarks in the child's life or how they're...
Okay, so let me, timing-wise from when that happens, like when you're not here or you're incapacitated before somebody gets appointed, or?
Yeah, I guess in the planning phase of it, I guess how involved are the two parties if they're going to be different? Should they be?
They don't interact until the time happens. Okay. So what I do tell the clients, so please have conversations with these individuals that you have in mind, because the last thing you would want, if they have any reservations about serving in either of their roles, that they let you know now. That way, if something were to happen, we're not scrambling. If they, and it's, if you're going to, some families have 2, 3, 4 children. That's a lot of children you're inheriting. And so giving them a heads up, letting them know is very helpful. And then in those instances where we do have families that have a lot of children, bigger families, they do prefer that divide and conquer approach, because that is a lot to put on one person to take care of. So we've talked a lot about what to think about who to choose. Also, just as important, especially when it comes to money, is disqualifications. So what does that mean? I tell clients, if there is anybody related to you that you would never, ever want to serve in a fiduciary role for yourself or on behalf of your children, you also want to tell me that, so we can also put that language in the documents to say, never ever should this person ever be in this role. When it comes to guardianship especially, so the guardian declaration is guidance for the court, meaning the court, when they're looking at who to appoint to guardian, they're going to give a lot of deference to you and what your wishes are. But ultimately, their standard is what they believe is in the best interest of the child. And for every guardianship, there are multiple interested parties who could make a assertion, a request to be appointed guardian. But if you took the time and said, look, never ever should my cousin Billy Bob Joe, who I have no relationship with, or for whatever reason you don't want, we put that in your documents. The judge, even if they think this is the best person, they cannot appoint this person because you specifically disqualified them. So that's really important. Yes?
So if you disqualify, let's say I disqualify for one of my children,
Uh-huh.
will they know, like after I pass? Are they going to see that I disqualified them?
In the documents, yes, because that would be filed as part of the guardianship.
Gotcha.
Yes.
Okay.
But if your reservation about that is hurt feelings, when it comes to your estate plan, don't worry about hurt feelings. Really, your estate plan should reflect what you want. But good question. Any other questions? Okay, so we talked about a capacity planning. Summarize. Healthcare decision maker. Healthcare decision maker needs to be strong enough to adhere to my wishes. They need to make the difficult decisions that I can't make for me. Healthcare, that's healthcare. Financial decision maker. So this is your financial power of attorney. This is your guardian of the estate for you or for your children. This is my money person who is going to manage my money for me. This is who I trust completely because I'm going to give them immediate access to my money to take care of me if I'm incapacitated. And after I'm gone, I'm trusting them to take care of my money for who I'm leaving it to. Completely trustworthy. So those are the powers of attorney. The third role, guardianship of the person. Guardianship of the person for you is who's going to manage you or take care of you. If you're sick, taking you to the doctor, for instance, taking you to your physical therapy appointments. If you're disabled, guardian of the person for my children is going to be managing them day to day, taking them to school, making sure that they are doing their homework. If they are at extracurricular activities, taking them to practice. When they're sick, taking them to the doctor. Those are the different roles that you're going to be appointing for incapacity. Okay? The other flip side of estate planning is death planning. So let's say, back to our bus example, death planning is you didn't survive the bus crash. Sorry, you are no longer here. What does that look like? What are the documents that can come into effect, apply at death? The first one you will see on that chart on the handout is beneficiary designations. What is a beneficiary designation? If you set up, for example, a life insurance policy, you are entering into an agreement, a contract with this life insurance company to say, look, this policy that I have purchased, if I am gone, this is who I want entitled to this policy. This is who my beneficiary is. That's a contract that you have, whether it's with New York Life, Prudential, any other life insurance provider. That's the contract you have with them. What does that mean? That contract supersedes any other document. Okay? Life insurance is a primary example that has payable on death or transfer on death designations. Bank accounts, sometimes you'll see ROS on bank accounts. What is ROS? ROS is right of survivorship. What does that mean? If you set up a joint account, you see it a lot with husband and wife joint accounts, and you see ROS. Right of survivorship. That means if one of those spouses predeceases, whoever survives then becomes the sole owner of that account. That is right of survivorship. But in addition to that, you may see payable on death, POD, TOD, transfer on death, designations where you can allow and name a beneficiary on an account. Meaning if something happens to both of us, who do we want to own this account? You also see beneficiary designations for retirement accounts, especially 401ks, IRAs. You should have some type of designation for every account you have, except if you intend to name a minor. You do not ever want to name a minor as a beneficiary of an account. Let me please repeat that. Do not ever name a minor beneficiary as the owner of your account. Why? Minors have no legal capacity to go get that account, go get that life insurance policy. So this is how this will play out. If you name your minor child as the beneficiary of your life insurance, that life insurance, let's say we'll go to Prudential. Prudential sees that, look, this person's a minor. We can't give this money to a minor. So they're going to force your loved ones, your guardian, whoever's in charge of your children, to go get a court order to release those funds. The court is going to see, okay, yes, this person should be entitled to, but because you have nothing in place, the court is within their jurisdiction as part of that to say, look, okay, Prudential, you release these funds on behalf of this minor child, but because this minor child is still a minor, we are going to take that money and let's put it in a court-managed trust for them until they're an adult. What does that mean? Any court-managed trust is minimal growth potential. It is the most conservative investments you will ever see. And then anytime your guardian needs a distribution on behalf of your child from that court-managed trust, they have to hire somebody like me to file a motion to get those funds released. Anytime an attorney touches a file, that costs money from fees and attorney's fees. So the amount that you thought you were leaving your child in his life insurance policy through that court managed trust is going to be significantly diminished by all of those. Okay? So my biggest PSA for families is do not ever name your minor children as beneficiaries. The other conversation I've had with families is, okay, well then I will leave uncle, my brother, uncle so-and-so, as the beneficiary of this account. What happens there? When you do that, if you name, even if your intent was that, I've talked to my brother, he's going to take care of my kids for me. If you name him as the beneficiary legally, that's his money. He is not legally obligated to use that money to take care of your children. And there have been situations, unfortunately, after a death where maybe a child pisses off their guardian, but because that person has that money, they're going to hold it. And we're like, there's no more control. Okay, so legally, that's their money. They can do whatever they want. Not saying that your brother would take and run with it, but it does happen. There's other ways to get around that. Okay. The next document for death planning that you see very common is a will. Almost everybody should be very familiar with the will. A will, the day you sign it, it's a valid legal document, meaning in this will I have named an executor. Who's an executor? Who I want to be in charge of my estate. You can name beneficiaries. Who do I want to benefit from my estate? And you can name and list what it is you want to give them. The biggest thing though about a will, and this is my other PSA, in addition to don't ever name minor children, my other big PSA is a will is subject to probate. Meaning, the day you sign that will, it's a valid legal document, but it does not authorize valid legal authority until two things happen. What are the two things that have to happen? Number one, you gotta die. And then number two, whoever you've named as executor in that will has to hire somebody like me to take that will and probate it. Meaning we take that will, we apply for a probate court to admit it. The court, as part of a probate hearing, will examine a will, examine our application, and only if they agree that yes, okay, this individual passed away, and yes, we agree that this person should be executor, not until that court signs that order appointing your executor does anything get done on behalf of your estate. Okay. For an example, and this is probably one of the worst case examples I've had recently, I had an estate that we were probating. Unfortunately, that person died without a will, which is a much more complicated probate. This individual died without a will. We applied for probate in Harris County. There are currently 5 probate courts in Harris County. You get randomly assigned when you file. The court that we landed in, they are not as efficient with their dockets. I filed that probate, opened it in September. I could not get a hearing scheduled on that matter until March of the next year. That is, 6-7 months of time that nothing is getting done on behalf of your estate. That's one of the first drawbacks of probate. The second drawback of probate for my clients is it is a public proceeding, meaning you guys can go online right now in Fort Bend County, Harris County, the surrounding counties, and see all the different probates that we're currently involved in. And so if privacy is important for families, let's stay out of probate. Why do we want to give people privy a reason to look into our personal matters? Cost-wise, I do probate all hourly work, meaning there are too many moving parts that I don't control, so I'm never comfortable quoting probate work flat fee. But I've been doing this for almost 18 years now, so I have an average amount of time that a family ends up paying us in fees from start to finish, because it's not just getting you to the hearing. After the hearing, there are things that we have to do for the probate court. We have to file a notice to creditors, we have to file a notice to beneficiaries, we have to file and complete an inventory, meaning we have to list everything that has gone on in this estate, what it's worth. And then we also have to address creditors that make claims. all of that process from start to finish, on average for a family, and I have a goodwill, let me asterisk that. What is a goodwill? My goodwills are properly executed. By and large, those are not my DIY wills. My DIY wills are going to be my more expensive probates. But on average, families are paying us anywhere from $4,000 to $6,000 in attorney's fees. Just to open up the probate, it costs about $400 to $500 in court fees, depending on whether or not you're in Harris County or Foreman County, for example. So if we can help a client avoid probate, that is also what you're saving your family. You're saving them, you're allowing them privacy to mourn, to grieve, and to try and move forward. You're also out allowing them to save in time and money there. Okay, so questions? Yes.
So what do you do if you do have a minor child
Yes.
and you want to give them assets without going through probate court?
Yes.
Or did you use like a trust or something?
Bingo.
Okay.
Yes, so the last document listed in our chart is trust planning. Compared to what is will versus trust. Those are probably the two most common estate planning strategies you hear. A trust is a legal entity. There are three parties to the trust. The first one is the grantor, who sets up the trust. The second party is the trustee, who is managing the trust assets. And the third party is the beneficiary, who benefits from this. A grantor trust is probably one of the most common trust plans we do for families. Very common with families who have minor children. Okay, so a grantor trust is, are you married?
No.
Okay,
Separate.
so you're separated. Okay, but you have how many kids?
One.
One. How old?
Turns 5 this month.
Okay, so 5 going on 15?
Something like that. 20.
Okay, so you, if you were to set up a trust, you would be the grantor. I mean, you're the person setting it up. And then because it's your trust, you also will be the trustee. You can manage the trust while you're still alive, and so long as you have capacity. And then you are also the primary beneficiary. Who benefits from it after you're gone? That's where you can list your daughter or son?
Daughter.
Your daughter as the primary beneficiary after you're gone. What does that mean? Once dad's gone, this trust then owns all of these trust assets for the benefit of your daughter, but she's a minor, she's 5. And even when, legally, let's be honest, 18-year-olds are legal adults. I have a 20-year-old and a 22-year-old, and to their credit, they are responsible young adults, but I am not comfortable giving them outright access to what their father and I have spent our entire lives on. And actually, if you kind of think back to your 20s, at what point did we make more sound financial decisions? It wasn't really in your 20s. It was a lot later. And so for our trust, one of the most common things that we put in trust is rights of withdrawal or fractional distributions, where we set it out, we stretch it out. The most common distribution scheme that we have for families with young children or young adults is age increments. The age increments is 25, 30, 35. That's probably the most common, meaning at age 25, your child can request a third of what they're entitled to, their share of your trust. 25 is a nice milestone because if they went to college, they would hopefully graduated with an undergraduate degree, or if they didn't go the college route and they went some other career path, they would have had a few years in that career path. 30 is another nice milestone because maybe they're looking at purchasing their first home, and that could help with a little bit of a down payment. 35, most of my parents are okay with giving their children outright access at 35. Those are what I call big checks, 25, 30, 35. But in the interim, anywhere in between that, there is a distribution standard that we call, it's an acronym. There's a lot of acronyms in estate planning. This one is HEMS, HEMS, health, education, maintenance, and support. Anything that falls under one of those 4 categories, your trustee can pay on behalf of your child directly to the third party. So health, always making sure they're insured, helping pay for doctor's bills, hospital visits, for example. education, paying tuition and books on behalf of the beneficiary, maintenance and support, cell phone. Everybody has a cell phone nowadays, so helping pay for that cell phone bill. Another maintenance and support example is maybe your child needs new tires for their car or needs a new car. The standard for HEMS distributions is what mom and dad would have provided if mom or dad were around. So what I explain to clients is this: if mom and dad were not going to buy you a Ferrari when you turned 16, it's going to be very hard for your trustee to justify the purchase of a Ferrari. As a side note, please do not ever buy your brand new teenage driver a Ferrari. That just is not smart. And the fact that I have to say that means that someone thought that was a good idea. So don't do that. But anything that falls under HEMS, your trustee has the ability to pay on behalf of your children directly to the third party. So for example, back to education, tuition and books, you pay it directly to the university. Okay? So if you're paying for the cell phone, you pay it directly to Verizon on behalf of the beneficiary. That's how we put things in trust to take care of minor children, young adults. But there's other advantages to trust planning, meaning a trust, the day you set it up, it is a valid legal document that authorizes immediate valid legal authority, meaning whoever you've named in the role as trustee, they step into that role if something happens to you. We don't have to go to probate court to get permission for this person to act on behalf of your trust. So we avoid probate. It is private, meaning trust plans, the things that you put in that, who you want to inherit from you, what you want them to inherit, that is a private document. And I tell clients, very few people are privy to these terms. It's nobody's business. And so privacy is important. That's another reason why to do trust planning. We also have, for our beneficiaries, inherent creditor and predator protection that is built into things that are held in trust for beneficiaries. What is creditor protection? This is the example I give. And this probably would apply to anybody in here because we all drive. Our biggest risk of being sued is getting into a car accident with somebody, okay? In that instance, if you get in a car accident and are subsequently sued, because we live in unfortunately, a very litigious society, you are sued and there is a judgment, this person wins a judgment out there against you that exceeds whatever your liability coverage. That judgment creditor for a beneficiary cannot force a payment out of your trust. So I'm going to use you as your example. Later on, your daughter gets in a car accident with somebody, and there's a judgment out there. That judgment creditor cannot force a payment from your trust that you've set aside, which she benefits from, to pay off her judgment. That's creditor protection. The other protection that is built in to the grantor trust is predator protection. What are our predators? If you can imagine, there are certain individuals, or let me just back up. The divorce rate, about 50%.
How much?
50%. So on average, half of marriages do not work out. And if your child gets married but subsequently gets divorced, anything that is held in your trust for their benefit cannot be included as a division of assets in that divorce proceeding. It is a separate property asset. Okay, so there's creditor protection, creditor protection. We have provisions there that allow our children to grow, become productive members of society before we're willing to give them outright. And so it allows them not just to, I mean, everybody's probably familiar with the trust fund baby term. That's not who we're raising. That's the majority of my parents don't. You worked hard for what the net worth you've built. We're not just going to hand it over. Okay?
I have a question.
Yeah. On.
So let's say if, my son inherited the house within the trust that was left for him. He got married, his wife moved into that house, and that became her homestead. What happens when they go to a title company and sell? Because we, escrow officers, we would say, hey, because this is, now her homestead, right? So we have to have her sign docs in order to transfer title to. So what documents does my son show the title company that, hey, this is my sole separate property,
Sole
my
separate
inheritance.
Yeah, so it would be owned by the trust, not him. So if he gets it, are you saying he inherited, because you have 2 children, right?
Yes.
Yeah, so unless in your trust there's built specific bequest that leaves this house only to this person, that isn't owned by him, that's owned by the trust. So the
Oh.
trust is who's asserting the homestead exemption, not the spouse.
Oh,
Or the
so then
future
the house
ex-spouse.
would still be under the trust.
Under
It
the
wouldn't
trust.
transfer to his name.
Correct.
Oh. So
That's the
then
difference, the
would it even
distinction.
ever transfer to his name then?
Depends on the terms of your trust. If you earmark,
Would you want it to transfer? You as, an estate attorney, let's say for us, would you recommend?
well, just because of the scenario that you just pointed out, no. I would rather that it be owned by the trust, because if it's owned by a trust, it's governed by those trust terms. If it's owned outright by your son, and then he does get married, but then subsequently dies, that house, the surviving spouse has a life estate in it. So it becomes much more muddy and clearing. And we deal with that a lot with the issues, especially in blended families, where maybe the owner intended to leave it to his children who are not of the same marriage, but there's a surviving spouse there. That surviving spouse has lifetime rights in that home that are very protected in Texas. And so it becomes very, very complicated. So in those instances, that's what I'd rather just keep it in the trust.
So
After
I
you're
would
gone.
just suggest my son to never transfer it to his name.
Correct. Yes. Great question. Yes.
So I see revocable trust. I've also heard the term irrevocable trust. And what other types of trusts are there? I'm assuming there's probably a lot of them.
Yes, there are. So the biggest difference between irrevocable trust and revocable trust is the ability to amend. A revocable trust means you can change it over time. And that, by and large, is what I prefer for my clients, because it gives them the most flexibility. So long as you have capacity, we can change that over time. Irrevocable trusts, once you set that in place, nothing gets changed. Okay, so, and the other thing about irrevocable trust is you don't have a lot of control over the terms of that. Once you set it, it's kind of, visually speaking, it's set in stone. Okay?
So on a revocable trust, only the grantor can amend it.
No. No amendments at all.
No, on a
change.
revocable.
A revocable, yes,
Only the grantor can amend it.
correct.
Once the grantor is
Gone, it becomes irrevocable.
okay, that's what I was.
Yeah, so
So,
it then
so
gets
then
set in
wait,
stone.
can whoever is controlling, let's say there's multiple real estate properties in a trust,
Mhm.
and the grantor passes away, and now one of the children is, I guess, the trustee, can that child not then sell one of those properties out of the trust? Can they not, they can control everything within it at that point?
If they are serving as the role of trustee, yes, they are
They
the
have to
one
be
who
named
controls.
as trustee,
Correct.
and then can they name future trustees?
No, because at that time you're gone, it is governed by that trust agreement. It's irrevocable. So whoever you've named, as of your date of death, that's it.
And then they manage it until their death, and then what happens?
Well, it just depends on the terms of your trust and what was your purpose. Like if your children are above the age of 35, or maybe it doesn't make economical sense for them to carry it on, they can terminate the trust and then finalize distributions. I have other instances where families, maybe instead of doing the fractional, we have some concerns about beneficiaries where they have terms in the trust to carry it for the duration of their lifetime. So it just depends on the purpose of, or what your intent was when you initially started the trust.
Okay,
Can you respond to
I gotta think
questions?
about that.
Can you respond questions about capital gains on passing property
Okay,
from?
so for grantor trusts, we don't have to worry about they get the step up in basis too, as if it was a person that got it. That's a,
Can you explain that, step up in basis?
okay. So if you inherit it outright, so like today, dad left you a property, not in a trust, you get the step up in value, right? As of dad's date of death,
Cost basis.
okay?
Not cost.
The step up.
Base value.
Okay. Same thing if we were to put in a trust. So that's why it's also an advantage. If it's held in the trust, it also gets that step up, meaning we're not paying the capital gains until after you sell it later on. You get that, whatever the value of the property is as of the date of death, when the trust got that property.
Oh, so let's say I bought it for $100,000.
Mhm.
I died. At that time, it transfers to a trust and it's valued at $500,000
Yes.
versus my son paying capital gains on that $400,000. He now inherited at $500,000 cost.
Yes.
So he would only pay capital gains on $5,000 above.
Yes. Whatever.
That
Yes.
is
When he
the
sells it in the
basis
future. Yes.
Of the trust.
Yes. Yeah. So it's a really nice strategy when it comes to real estate. And that's another concern that folks have had too. Especially if you're good at real estate investing, you're leaving properties that have gained significant value from when you first bought them.
What about, I have a question, if we're talking about the step up value. So what if they did like a transfer on death deed?
Transfer on death deed, yes, should get the step up in basis. But I'm very cautious about transfer on death deeds depending on the nature, the type of property we're talking about. Is it a homestead? Sure. Homestead, I am comfortable leaving it to adult children. The thing about the transfer on death deed, you have to leave it to, it's in equal shares. So I have some families that have like 3 or 4 children, but they may be, because of financial circumstances, one child may be better off than the other. You can't do inequitable distributions in a transfer on death deed. They have to take it equally. However, for those instances where families maybe want different shares to go to different children, trust planning makes the most sense. We can do that easily through the trust. And I'm sorry, I just lost my train of thought. You're okay.
Transfer on debt.
Transfer on debt, thank you. So transfer on debt. If it's a homestead, not a problem. If it's income producing property, like a rental, I don't like using transfer on death deeds. That to me is what we call a high risk liability asset, meaning that you are more likely to be sued when you're a landlord of that type of property than homestead, because homestead is strong protections in Texas. In that instance, we oftentimes talk about planning through an LLC, okay, versus trust planning for that.
Can you put an LLC into a trust?
I connect, yes, to short answer, yes. But typically what I like to do for LLCs and trust planning is keep them separate as long as possible. LLCs, you can establish it and put rental properties in it, right? In Texas, LLCs are very attractive for clients because it doesn't require the same formalities that you need for a corporation. What is an LLC? An LLC, they're owned by members. They are managed by managers. For some families that set up an LLC for rental properties, it's all the same people. The big difference between an LLC with a corporation is an LLC, we can do actions on behalf of the company via consents, whereas corporations, you have to have shareholder meetings, you have to have meeting minutes, you have to have a very detailed binder. Why? If you are ever sued, and a little bit real quickly about Featherston Tran, my law firm, my business partner is my litigator. So how I kind of explain how things work is I work primarily on the estate planning side and all the uncontested probates, meaning if you're getting along, you usually deal with Thuy. If you're in a fight, see a fight coming, or want to start a fight, is when we usually bring Brad into the conversation because he is my litigator. So what does that mean? If we have somebody come to us saying we were wronged by this individual, we would like to sue them. If we agree that we think, okay, that you do have a cause of action, one of the things that we consider is if we're able and successful in getting you a judgment, how are you likely to be paid? And if in discovery, in a lawsuit, during discovery, we find out that the other side has a company, whether it's an Inc. or an LLC, one of the first things we do is we ask for company documents documenting that. so that we can see whether or not this is a validly run company. So if you can imagine, not everybody has, especially if you have these inks, those detailed company binders with all of these documented shareholder meetings and voting that had to do with the company. Whereas an LLC, it's a lot easier. The paperwork is a lot easier to manage and hold on to the LLC. If, as a litigator, we are successful in poking holes, the terminology you'll hear is piercing the corporate veil. If we can poke holes through your entity, we can potentially get to your personal assets. And so that's why if you're going to go the route of business organizations to protect your assets, I spend a lot of time with my clients making sure they understand that this LLC that we set up for your rental properties has to be run like its own company. It has its own EIN number. It has its own bank account. This bank account does not pay for your personal groceries. You can pay yourself a salary as a manager, but there's no commingling, because worst comes to worst, if you do get sued, that's what you're going to have to present. We don't want any piercing of the corporate veil. Okay?
So we have, our setup is we have one C corporation owns 3 S corporations, that are obviously LLCs.
Okay.
And set up a trust, how would you advise making sure that the employees were able to run the company in my death for S corps?
Is your intent that they have ownership interest in it?
See, that's the, I own all the shares for all 4 entities, and I'm not really so sure of how that would transfer over if I were to die.
So do you have any kind of will or anything in place?
I actually don't. That's what made me come to this class, because I feel like at this point in my life, what I've amassed, if I were to die, it would be a mess.
Yes.
Like, for people to figure it all out.
Yes, it would. And I don't know if the people in your life get along.
Yeah, I mean, everybody's pretty cool and close,
Yeah.
but
So
I
we
like
would,
for certain people to do certain things, and that's why I need to get this done. So.
yeah. So you would really want to document who you envision, who you would like to leave these companies to, who you would like to name, and then we can talk about the best way to document that, whether it's through your LLCs or through your trust document that then maybe connects the two after you're gone.
Okay.
Okay? Yes.
I'm gonna piggyback off what you let's say, but there's 2 different things. Running and owning is 2 different things. As a corporation, you can have things in place so your business continue to run while you're figuring out ownership change. That's something I went through with one of my clients recently.
So what, depending on the type of corporation, so if it's like, as long as it's not a professional corporation, like,
You have to have a license to run, yeah.
Yes,
It's professional
that's it.
corporations. That's the problem, that not everybody's licensed to do these activities, which creates a legal issue of them running the company from a legal standpoint.
yes, they will have to have the
They have a
license.
license to operate, yeah.
Yes. Unless there's somebody that you trust that you would like to bring into the company, maybe that you could make an agreement with another realtor or another broker that says, okay, if something happens, we can take care of each other's. We see some of those kind of purchase sale agreements after a death. There's other instances where maybe companies will purchase life insurance, where kind of buying people out and then winding down the company. Because also the other thing for you to imagine or also consider is the success of your company is built on your goodwill,
Right.
your name. And that success may not continue if you're no longer here. And so for some owners, some business folks, it makes sense to maybe put life insurance policies in place to take care of those people. Because that's what I imagine why you would want to take care of them if you were no longer here.
Exactly. Yeah.
And then I know enough tax law to know I don't know enough, so I would want you to double check with your CPA, but sometimes those kind of transactions, purchasing life insurance through the company, may be tax deductions of some sort.
Yeah, we
You can
do
also-
offer life insurance to all employees, and we do get a deduction on that on the health benefit side, so yeah, but.
So that might
That's a
be
good
another
look at.
solution. So kind of different things. And when it comes to estate planning too, I always explain, I want it as like a team approach, meaning you probably have different people in your life that you trust. So you guys all are in real estate. So your clients trust you for real estate advice. When it comes to estate planning, I am the estate planner, but I also want to have conversations if we can. If you've got an advisor, a financial advisor on your side, let's bring them also into the conversation. If you've got a CPA or another tax advisor, have us all come so that everything across the board, like I may have not considered other tax consequences because I don't know your entire tax situation that would be important for that person to have input in an estate planning consultation. So, hi.
So I closed a client yesterday on a builder. And so he wanted to put his new property Airbnb into his LLC, which we did. But he had set up Series LLC. So I get really mixed information. Does Series LLC really work? Because to me, there are attorneys that tells me, there has been no proven case that it protects it. The best way is to separate each one into its own individual LLC versus the Series LLC.
And that's my approach being, so what is a Series LLC? It's a very relatively recent business org setup that was allowed here in Texas, meaning you can set up one like kind of umbrella LLC and then other mini LLCs, but they flow through the same. The theory behind it when it was first set up was to kind of ease administration, right? Because Brad and I have been practicing for so long, and because Brad brings in the litigation experience that we have, we are not comfortable with the way the law is written and the way the case law has developed over time to see that the advantages outweigh the cons. Whereas LLC planning, where it's individual, I do have some clients, I tell clients, let's not put more than 3 to 4 rental properties in one LLC. I would rather spread out, because you're spreading out your risk. But we have seen LLCs work, and the case law is there. It's established that protects things that are owned by LLCs that are run correctly, whereas we haven't seen the case law play out with the Series LLCs. And then from what I understand, the Series LLCs, the documentation that was required, by and large, most people aren't doing it. And so if you aren't doing it, then again, you go back to that piercing the corporate veil, which then puts our clients, kind of defeats the purpose. You don't have that protection. Yes?
I have another question, and I may have missed this part, but you want to do multiple LLCs. Is that so if for some reason that LLC was sued, it's not affecting
Everything else.
all of your
Yes.
assets if
So-
you had them all under one LLC?
Correct. So I like buckets. So let's say you have a dozen rental properties. Let's not all put those eggs in one bucket, because worst comes to worst, you could put everything else that's in that bucket at risk. So if you have that many rental properties, what I tell clients is let's spread it out. Let's spread it out to maybe 3, 4 buckets. And so the worst, that's all you're risking in that bucket. The other thing is we don't want to put personal assets in LLCs. Your personal assets really should go through your trust planning documents, because those are personal assets. Those are protected, but we want it separate. Visually speaking, buckets is what I call those. Okay. So I spent a lot of time telling you the good about trust planning. I don't do my job if I don't tell you the good, the bad, and the ugly. Okay. Trust planning, we can avoid probate with one caveat. It is trust funding homework. Okay. I kind of giggle because I used to be a teacher. I still assign homework. This homework is the trust funding, meaning visually, the day you set up a trust, it is an empty bowl until you take all of the assets that you want governed by your trust and you execute the documentation to document that you want it owned by this trust should something happen to you. I do a transfer on death deed for all homesteads for my trust plans, meaning even though the trust does have language allowing any property owned by the trust to assert homestead exemption, in my experience, it's just easier for clients to maintain it in their individual names, especially in Harris County, depending on who's processing. The clerk's office is processing their deed. And it gives them most flexibility, meaning if they want to downsize later on, they can easily sell the property because they still own it. The transfer does not happen until death. Everything else though, whether it is a bank account, a life insurance policy, every other asset, if you want it governed by your trust, you will need to do either a beneficiary designation to the trust or some other documentation with that financial institution to document that you are appointing it into the trust. For the most part, most of my clients will do beneficiary designation. That typically is the easiest way to fund your trust. But what I tell clients is this, different financial institutions have different preferences for what they like, meaning Wells Fargo will do very different from Chase, which will do very different from Bank of America. So the conversation I tell clients to have with these banks, financial institution, is you go in and you say, look, I now have a trust. If you're married, what do I document with you? What do we document with you to let you know that we want this account to go to our trust after we're gone? Whatever form it is that they have you fill out, make a copy of it, put it with your binder so that that is proof that you did your trust funding homework. Because especially with the big banks, one department doesn't always talk to the other department. So if you have that documentation in your binder, it is evidence. It is easier for your trustee to go back and say, look, I know on this date, they filled this out with you guys. I have it right here. It's very helpful. Okay, so trust funding is the biggest part of making sure that you establish a trust plan that avoids probate. Okay, I still have clients do a will with a trust. It's a very short will. It's a pour-over will. Pour-over because the main provision in that will says if there is something that I didn't have in my trust, I want it taken and poured into my trust. That's all it is. My goal is we don't have to use the pour-over will, but I still have my clients execute it because in Texas, the most common example of why we may need to probate an estate afterwards is an inheritance of oil and gas interest from a long lost uncle. We didn't know about it. Hasn't happened to me yet. I'm still waiting for that long lost uncle to leave me some oil and gas interest, but it does happen. You didn't know you were going to inherit it, so that's why we couldn't fund it in the trust. Yes, we do have to probate, but the good news is it's typically a very simple probate to do. Okay.
So let's say I'm incapacitated and my husband has a power of attorney,
Mm-hmm.
right, the financial. So can he take that to the bank and, you know, pull money out of my account or close my accounts? Because I've heard banks turn, you know, people down even with a power of attorney.
For the most part, our statutory durable power of attorney that we have gets our clients where they need to be. There are some occasions where we have had some pushback from some banks. So not that it's never happened, it has. But for the most part, the one that we put together, and our financial power of attorney is like 11 pages long. It's longer than our pour-over will because we break it down. Because we've had so many scenarios play out where we include these hypothetical scenarios. A general power of attorney will just have like a laundry list of general powers that you're giving. We actually have a section in our power of attorney that lays out these specific examples, meaning if I'm incapacitated, yes, my agent has the ability to change beneficiary designations for me. Yes, my agent has the ability to establish trust planning for me, a special needs trust, a Medicaid trust, for example. So for the most part, our clients are successful in using their powers of attorney to address those situations, but I'm not saying it's foolproof. Okay.
Okay. So I feel like that's a good question in relation to title companies because we have to call the power of attorney to make sure they're alive and well, and in situations where they are incapacitated or have dementia or something like that, where we can speak to that person, then we have to speak to the attorney or the doctor or someone confirming, like when they signed the power of attorney, that they were in a right state of mind.
That they had capacity to do what they were doing.
That's why I think it's important to have it done by an attorney versus just printing one off of the website and signing it, because if you ever are in that situation, there's no one that
To
can
verify.
Yeah. So like, do you ever have to do that like in a banking situation? Will
We've
they
been
ever-
fortunate because part of my execution of documents is witnesses. So I have 2 people that witness you signing your document. documents, and these people are not related to you, meaning they have no skin in the game. That's really important, disinterested witnesses, because we've had documents where they come to us and who signed this? Oh, my son signed it, who I've also named as my primary beneficiary. That's an interested party. Yes, very important, which actually brings me to this, my last slide. Can I draft my own estate plan? Expectations versus reality. And so, yes, there are DIY wills and DIY trusts on there. I like to bake. I'm not a great baker though. I'm not a professional. I can do my nails if I'm in a pinch, but they won't look as good as when I take it to the salon. And I can try to take a picture, but I guarantee you it's gonna look more like the one on the bottom than it will on the top. And so what I tell families is this: I've been doing this for a long time, and we have seen it go wrong. Just think about the time that you've taken to acquire your wealth and what's taken you to this point. And the people, the professionals kind of along the way that have helped you. There is a reason why I have a license, why you guys have a real estate license, because you have gone through the training to know what to do for these situations. And so that's where I implore clients. I'm like, yeah, you can. I will tell you, the probates that we get involved in, that families end up paying us the most are the DIY ones. It really is. It's the ones that somebody found on LegalZoom or somebody printed out online, filled it in, thought it was going to take care of what they want, and it doesn't. I'm doing one right now, actually. The gentleman, and it was really heartbreaking because it was done through some kind of program through their church. But the gentleman had 5 children. He only listed 2 of his children in the document, in his will, and then named an uncle who he doesn't really have a relationship. So I don't understand the thought process. Based on what I can see, it really was just somebody plugging in things. And so that one is it's a mess that we're having to unravel now.
It's like the one plan that can't be fixed after the fact because you're dead.
You're dead. Yes, so it's leaving everybody to scramble. And then even, people, believe it or not, people don't always get along. When you lose a loved one, sometimes there's glue, and when the glue breaks, blended families, that's probably another reason, example, and probate.
I'm agreeing with that. I'll say an example, because on title side, we see a lot of transactions where either people didn't probate a will or whoever passed didn't have a will. And so we'll go and do an heirship affidavit. And a lot of times they think, oh, it's going to go to the spouse. We'll come to find out the husband or wife who passed away had children from an outside marriage. So now it's the wife that's vested in title and all the children.
Mm-hmm.
And I had a situation, and it ended up, it all worked out, but the stepchildren were a lot more willing to sign the deed to their stepmother than her own daughter, which was wild to me. I thought it was going to be the other way around, because we ended up having to be the one to break the news to the mom and then call all of her stepchildren and her daughters to let them know what was going on, that they were either going to have to do deeds or have to agree to the sale and sign all the closing paperwork. So that gets really messy and emotional and
We've got stories. I mean, intestacy, dying without a will. Oh my goodness. I had a husband and wife. They'd been married for 20-something years. He passed away, unfortunately, during COVID. They had no children together. And he had no will. So who is entitled to an interest in this? He actually was predeceased by a brother that had never probated his estate. So we actually ended up having to do multiple probates. But who is entitled to his separate property, and the home that they had was purchased before marriage that he had purchased, so it was his separate property.
How do you prove that if the wife lives there now?
She lives there, so she has her life estate, but in terms of full ownership, it's separate property, so it's split 1/3, 2/3. 1/3 to the spouse, 2/3 to whoever else is entitled. He didn't have children, he didn't have surviving parents, so the next people out were his siblings who he survived, so then it actually went to 2 nieces that he had no relationship with. And we were contacting, and they were in a rural county, had no relationship with this individual. And we had to let the spouse know, sorry, we have to let them know because they are entitled under intestacy laws to 2/3 of his house. She was floored.
Because he bought it before he got married, even though they.
So she has a community property interest. So where we were able to negotiate with the nieces is, yeah, you have an interest, but let us calculate your actual interest because they've been married for 25 years. Her 25-year community property interest in the mortgage payments paying off of this house had to calculate all that she had paid for, property taxes, insurance, and calculating, showing them, look, this is, you want yours, this is what you're supposed to reimburse our spouse for. So that number was enough to let them see, okay, yeah, we may be entitled to a certain percentage, but maybe it's not worth us economically following through. But she had to pay us an attorney's fees to help them sort through that. Yeah. Intestacy, there's a lot of fun intestacy stories that we could tell.
We have one where a stepdaughter ended up getting an attorney and getting funds from a person. And it was a ridiculous amount, but the wife who was living didn't have any cash flow to fight it.
It gets really ugly, y'all. And so, I mean, at a minimum, have a will. Have a will done by an attorney, please.
Questions. I have
Yeah.
2 questions.
Sure.
One, first is who typically acts as a trustee? Is it a bank, an attorney?
It can be. There are banks that have trust departments. There are third-party professionals who serve in the role. Most of my clients, depending on the value of the estate, right, and the type of assets, they will typically name somebody close to them, maybe a sibling or a close family friend as a trustee. Where we may bring in a third-party professional or a trust company is when a client doesn't have that confidence in these people to serve in that role. So
Trustees can't be beneficiaries.
they should know. They can, but you are also trusting them to whatever decisions they make, and that role of trustee is not just for their benefit, but for all of the beneficiaries' benefits.
Okay. And then my second question, you had touched on the average costs to go probate.
Mm-hmm.
Do you have such numbers for creating trust and
Oh, sure.
doing that?
Yes. Okay. So, unlike probate, I have a comfort level of the time that's involved for me to do an estate plan for a client. So I typically hold a consultation. I do all my consultations via Zoom, which is really convenient. We hop on a Zoom call. I spend an hour. I take an hour of my time, dedicate it to you to figure out what it is you're trying to do and what my recommendations are based on that. Also, part of that conversation, I'm evaluating any state tax concerns in addition to asset protection risks that you have. If it is something that warrants a trust plan, my trust plans start out at $2,950 for a single person, for one revocable trust. There are situations where we may need multiple trusts, typically in my blended family scenarios. Will-based planning, there are occasions where I do wills only based planning for families. Typically, it's my older folks who maybe are on fixed incomes, maybe only have a house, a few accounts. Those are candidates for will-based planning because all of their children are doing well and we don't have concerns, and we can do will-based planning with all beneficiary designations on all accounts where the will is there if we need to, but we do a transfer on death deed for the homestead, and we make sure that they know to do their homework and do updated beneficiary designations for their accounts to their adult beneficiaries, adult children or adult grandchildren, for example. Will-based planning starts at $24.50. All my plans include all of those incapacity documents that I mentioned. Incapacity is all of those powers of attorney, medical power of attorney, HIPAA authorization, the directive to physicians, the financial power of attorney, and then the guardianship document, especially if we have younger children. We're going to do a guardianship. My consultations for anybody outside of this room are $100 for that 1 hour of my time, with the opportunity to apply that as a credit to a future estate plan. Because you all are attending this class, I will waive that fee, but you have to tell me when you reach out to me that you were in this class.
It is via email, correct?
Yes, my email is right there on that form. I also have some business cards here.
Okay, I have 2 follow-up questions.
What?
Those answers led to 2 follow-up questions.
Yes.
The first is, do y'all work on special needs trusts?
I do some special needs trust planning depending on what the reason why we want to do. Is it built in for
Special needs child?
Yes. So it depends. We have to be very careful because a lot of special needs individuals are recipients of government benefits and things that they own. If it's a means-based type, need-based kind of program, could disqualify them. So we have to be very careful. So yes, we do.
Okay. And then my second question is, my wife and I and our daughter Lexi, we kind of went through this process a couple of years ago, 2-3 years ago. Do you ever review other attorneys' planning? Like, can I bring all this to you and say, what exactly do I have here?
Yes, I do. Unfortunately, I don't do that free of charge.
Of course not. I wouldn't expect you to.
That would be at my hourly rate. My hourly rate is $3.50 an hour.
Okay.
So depending on how many documents it is. Did you go with an estate planner or just an attorney?
So he's an attorney who specializes in special needs trust because he has a child of his own that's special needs. And he was recommended by several people. That's why we went with him. But the entire time we were talking to him, it's like he seems to just make assumptions about our level of knowledge with all this, and getting him to kind of go a little bit deeper with it was sometimes very difficult. So we have this,
Okay.
but we're not
But you don't understand what you
exactly
have.
We're not exactly sure what we have, and we're not exactly sure. And we'd like some input as to reviewing how it's set up, if there's a better way to set it up.
Okay, sure.
So,
You've got my contact information.
I do.
We'll set up appointment.
Okay.
Okay. Yep.
So you have 2 kids, do you need two separate trusts for each kid, or just one trust to encompass both kids? Or
If they're minors, one trust should take care of it. Where you may see maybe different trusts is if, as your we've seen families where the children, as they're adults, we have what we call problem children. Maybe one that is gets in trouble with the law, has alcohol, drug abuse issues, where maybe we want to keep things separate. So it just depends. And sorry, that's going to be my answer for a lot of questions. It just depends. So I would want a more detailed conversation with you and learn more about your children and ultimately what your goals is for them. Okay? Hi.
Just have a question. It's 2 questions. First one is, once you have a will or a trust established, should you let the people, the beneficiaries, know about it, or wait till you die and then let them find out? Secondly, is if they live outside the state of Texas, let's say they're outside the different part of the United States, or let's say outside the country, how would they be contacted if you
They being your beneficiary?
Yes.
Okay, so your trustee would be responsible for gathering trust assets and then figuring out who the beneficiaries are and what they're entitled to. So that is going to be the responsibility of your trustee. So that's why this person should be so trustworthy. That's the first thing that you're going to be trusting them with, is doing all of that for your beneficiaries. And whether or not they live in another state, that's typically not an issue, especially nowadays. Everything is done so much is done electronically. So it's maybe just a function of like setting up different accounts for them. Where it's a little bit tricky is maybe our international beneficiaries. That is a little bit tricky.
And how about the, once you have a trust established, do you need to let, or will you need to let them know, is it recommend to let them know before you pass, or you just kind of don't tell them?
I would tell your first person in charge for finances. So your, if that person happens to be your beneficiary, they'll know. But I would say, so we put our documents in a binder for folks. I tell them put it somewhere safe. So if you have it in an office or you don't have a safe, let somebody know where it is. In Houston, if you don't have a safe and you're putting it in your office, put it up somewhere high, because our most common natural disaster is flooding, so you want it up high. But do let at least one person know where it is these important things are going to be. So should something happen, like if you go travel, or you know, hey, I'm going to be out of town, this is where I want you to if something happens, and this is where you need to start.
So you do provide it on a thumb drive
I do.
and electronic copies.
Yes, yes.
So you can store it in the cloud too, or email them.
Yes. So we are a cloud-based law firm. So what that means is we set up all our clients with client portals, very similar to a patient portal. All of digital copies of everything will be uploaded to your client portal there, and then you can just log in. If you're traveling, you have internet access, you can log in with your username and password. So what that means is all of my meetings are appointment only. We office with Regis, which is like office sharing. So I mainly work out of our Park 10 location, which is off of I-10, very close to Topgolf. My business partner, who works out of our Chasewood location, off of 249, kind of closer to Tomball, Willowbrook, Tomball area. So that's where our in-person meetings go. So kind of if anybody asks you, this is how our process is for estate planning. I do consultations. If a client elects to work with me, we gather information, their decisions, I prepare the documents, and then we have our in-person signing. In-person meeting, I spend the first hour and a half of that meeting going over every single document that we've drafted. At the end of the meeting, I bring in the 2 witnesses to watch you physically sign your documents, and then I notarize. And that's our kind of process of how we work for estate planning. And that's because I control that process, that's why I'm comfortable quoting flat fee for that versus probate, which is all hourly. Thank you guys so much. Great questions.
Fantastic.